Assalamualaikum and hi, my name is Atira binti Rosli. Today, I want to present about the task that given to us. The topic is about variation order. But first, let me introduce my another member in this group. Firstly is Muhammad bin Sadir Kaji American. Second is Adik bin Asra. Third is Muhammad Shahid bin Early Nizam. Fourth is myself, Atira binti Rosli. Fifth is Nurain binti Muqtah. And lastly is Siti Nur Umairah binti Mat Yunus. Okay, first, what is construction law? Construction law is a branch of law that deal with the matter related to building construction, engineering and related field. It is absent an amalgam of contract law, commercial law, planning law and tort. Construction law covers a wide range of legal issues, including contract, negligence, bond and bonding, guarantee and surety, tendering, and construction claim. Construction law affects many participants in the construction industry. For example, quantity surveyor, architect, engineer, builder, and planner. Okay, that's all for me. I want to pass to the next presenter.
Next, I will present and explain about variation order. What is a variation order? A variation order sometimes refer to the change order and the variation directive. It is a formal document that need to explain details about alterations and the original contract or agreement between parties participating in a building project. When a changes need to be made in the project, it is a scope of work, a timeline, and a cost. It is frequently employed in the construction business. In this report, the clauses also included. It is PWD, CIDB, and PAM. In these three clauses, the variation order also be stated. This is because this report have a companies that involved in variation order in the business construction.
Okay, for the cost that can be issued to VO is first design changes. In building projects, design modifications are frequently the cause of variation orders. The customer, architects and engineer may find faults, omission or discrepancies that call for revisions during planning and design phase. This adjustment may be necessary due to changing project specification, unforeseen site conditions or flawed design. Because they frequently call for modifications to material, labor or building techniques, design changes can have major impact on costs and schedules.
For the next course, I will be presenting about unforeseen site condition. Okay, well, I will be explaining what is unforeseen site condition. Unforeseen site condition is a condition where the contractors are told to not dig the land, and then when the work has begun, there are several things that has to be removed, such as a rock in the land. So whereby that case, that will be needed to open a variation order because it is a must do work for the construction to be built. The next cause is disruption in the supply chain, where any disruption on the construction work, there will have to be a variation order. Why? For example, if the concrete lorry did not come to the construction site, so there will be use of manpower to do concrete works. So we have to give the manpower their payment, which is extra for the construction project. So whereby this has to be open and a variation order.
Okay, for the first case is relate to paying contractor and subcon. One of them is the proceeding in court that involved Zeta Electric Sdn Bhd versus Jet Island School Sdn Bhd. The proceeding was held in 2017. So the main con is Jet Island School and the subcon is Zeta Electric Sdn Bhd. This case occur when there is a payment dispute between the main con and subcon. So the subcon filed an adjudication proceeding against the main con under the term of the Construction Industry Payment and Adjudication Act 2012, SIPA 2012, asserting claim for, among other things, unpaid certified amount, under-certified work, retention sum, materials on the job site, and additional variation work. So the subcon won the adjudicator decision. Main con ignore the court's decision. Finally, the subcon request payment directly from the employer in accordance with Section 30 SIPA.
Now I'm going to present about third case. Third case is Mars versus Statoil. Statoil case after of negotiations, the drilling and production unit Mars Inspirer was contracted by Statoil for operations in the Wolf field on the Norwegian continental shelf. The contract was made for 10 years and payment rates were fixed for various types of work to be done during the contract during that time period. In 2012, Statoil ordered Mars to drill additional wells on under the original scope of work of the contract and did not comply with the variation order at all, and also issued a variation order to carry out topside modifications to enable the unit to perform additional drilling services requested by the client, the said. Whereas Statoil, on the other hand, explained back to Mars that the order to drill additional wells was stated that it was within the original scope of work and did not require a variation order. After this case was discussed in the state court, the Stavanger City Court ruled in favour of Statoil because, in the opinion of the court, the drilling of additional wells was included in the original scope of work, taking into account, among other things, that the contract explicitly included the preparation to tie 5 additional wells.
Lastly, cases regarding variation order are Teti Engineering Sdn Bhd versus Faluh Tarwood Enterprise. In 2020, JKR issued a tender to a construction company, namely Teti Engineering Sdn Bhd, through direct negotiations to eradicate the flood situation on J4 Danga Bay Road, Johor Bahru. The Teti then appointed Faluh Tarwood Enterprise as subcontractor to carry out the maintenance work of changing the drain to a large size U-drain. In the contract, there is only the drain replacement work and also the replacement of the culvert under the entrance to Villa Nabila in Johor Bahru. During the culvert conversion process, the road leading to the entrance had to be demolished. After process of upgrading the culvert, the Teti has ordered and the road to rebuild and made as a variation order. But Teti did not pay attention to VO when the claim payment was carried out. The VO payment was not paid to the subcontractor. This matter was brought to court because the staff who gave the construction instruction has stopped and could not be contacted for a while. This case brought to court, and investigation was conducted to identify whether this instruction was valid or not. As a result of the investigation, the court ordered the main contractor to pay the subcontractor due to the negligence of the main contractor who ignored the VO.